Good afternoon, everyone. And want to extend our welcome. My name is Dan Attridge. I'm the Dean of the Law School. We're delighted that everyone could join us this afternoon for the Mirror of Justice lecture. This annual series, as some of you may know, began in 1989 to honor Mary under her title, Mirror of Justice. Some of you may know that our law school chapel bears the same name. So today's lecture has special significance for us. The lecture series is intended to recognize lawyers and scholars who, through their scholarly research and dedication to teaching, clarify and advance the pursuit of peace with justice through the law. This year, as you know, the lecture will be given by the president of Catholic University, John Garvey, who we are proud to say is also a member of our law school faculty. President Garvey will be introduced by Angel Hernandez, who's one of our students. Angel is the president of the Pope John Paul Guild of Catholic Lawyers. So please join me in thanking Angel for his organization's sponsorship of today's event.
Hi, I'd like to as well extend my welcome to every one of you, and again, thank you for your time. At this point, I'd actually like to call to the stage Professor William Wagner. He is the sponsor for our group, and without his support, very little what we do could be possible. So if you could actually please help me welcoming him to the stage.
President Garvey, Dean Attridge, esteemed audience, Angel has asked me as the Guild's faculty advisor to share with you something of the history of the Guild's founding and its service to the school, and something as well about the origin and purpose of the Mirror of Justice lecture. The Guild came into being this way. In April of 1985, that would be 28 years ago, 2 months after I first encountered someone named John Garvey, who was making a presentation on a panel at the AALS, and Occam's razor came to mind. His analytics were brilliant and memorable. That's 28 years ago. It's longer ago than some of you have been alive. It's half a lifetime ago for me. On that day, business had ended. It was after 5, the building had emptied, and as the last faculty member at my desk, I was still taking care of a few details. Evening was falling, it was wondrously still, and there was a small tap at my door. A student, Peter Fagan, entered. He said that he had been meditating on the meaning of the seminar, Sources of Christian Jurisprudence, which he had just completed with me. He said that he had concluded that the quality of the conversation and discussion in the class was so much a fulfillment of the purpose and identity of the law school itself, that he had come to believe that the seminar discussion should not be closed, but should be enabled to continue in perpetuity, and that it should be open to anyone interested in the entire law school. He wanted to know what we could do to make that happen. He and I had a nice talk, and he left. The next evening, the circumstances were identical. The building was very still. Again, everyone else had left. Evening was falling. I was working quietly at my desk. This time, a tap. A different student stood at my door, Charles Antonicelli. When Charles sat down, he said that he had been meditating on the course, Sources of Christian Jurisprudence, that we had just completed, and was inspired to come to me to ask what we could do to avoid closing the discussion in the class, to launch it in perpetuity for the law school community at large. Somewhat later, a few years later, on another evening, same time, Charles returned to ask for my blessing on his plan to enter the seminary. On that first evening, something very interesting became clear. Namely, Charles had not talked to Peter, but was sharing with me his own original idea. Or was it his original idea? I have little doubt that both Charles and Peter had a common source of their inspiration. And so it was that the three of us sat down and brainstormed the creation of a student group to be called the Guild of Catholic Lawyers, which was actually the course discussion launched in perpetuity, unbounded, not closed down, but to continue. More particularly then, what was it that Peter and Charles wanted to preserve and promote of that class for the future? This would be the class's quality as a community of inquiry into the sources of the meaning of our faith within the Catholic tradition for life under law. The manner of this inquiry was to explore with intellectual rigor the content of the thought of the biblical writers, the fathers of the church, members of the Catholic intellectual tradition, such as Augustine, Aquinas, and Duns Scotus, that had something pertinent to say on what it is to live under law in pursuit of peace and justice, and to creatively image apt applications of this rich body of thought for today. Such is the integrative power of the Catholic tradition and of the quest of faith for understanding, that the class was, and the Guild remains, a community equally dedicated to understanding alternative perspectives to the same questions. As we studied in the class, the Torah as well as Christian scripture, and Luther, Calvin, and Menno Simons as well as Aquinas. For the Guild is a community dedicated to understanding ourselves by understanding what we mean to others, simultaneously an exercise in self-identity and the sincere quest authentically to understand the other. Peter and Charles thought that this task rightly belonged as a component of any law school under the auspices of the Catholic Church and should enrich the community as a whole. The class had been, however, a community of particular people inspired in their individual lives uniquely by a devotion to the living God. They thought that such a group should be a font of inspiration and a blessing for all individual students, perchance faculty, felt called to the study of law in conscious affirmation of their Christian vocation. And that at the same time, as we sketched concrete plans for the Guild, we quickly settled on the wisdom of the insight that the Guild could contribute to our community as servants of all, that everything that the Guild members did in quest of realizing their individual Christian vocations would be oriented to serving with complete inclusiveness all of their brothers and sisters in the community as a whole. In these many years of the Guild's existence, other than perhaps spearheading the initiative that ended in our chapel being included in the plans for this building, that idea began in the Guild. The creation of this lecture series, the Mirror of Justice lecture series, I think is the most substantial of the Guild's many contributions. The lecture series was launched with the idea that the Guild could be and remain mindful of the work, especially of our faculty, not dedicated to telling our faculty what it should be doing in its scholarship, but respectfully listening and watching as the faculty did its work, to see sparks of inspiration across the whole range of the faculty that bespoke the purposes of the Guild with its quest to understand law as an instrument of peace and justice. Father David Granfield, a previous lecturer in this series and a deceased member of our faculty, whose spirit I'm sure is with us today, came up with a name both for the chapel and what turned out to be the lecture series. And the idea there is that the Blessed Virgin Mary, as in the Litany of Loreto, who is described as the mirror of justice among her other attributes, reflects the Sun of Justice, God's perfection and holiness in her perfect virtue. And so it is that the Guild means to be an inspiration to all of us, to allow God to help form us in virtue as we pursue our legal vocations. Thank you.
During a recent trip to Rome, the United States bishops assembled before Pope Benedict, and he shared with the bishops, Pope Benedict shared with the bishops his concern on the state of religious liberty in the United States. And so he called on the bishops of the United States to cultivate lay leaders to step forth on the public square and engage in these serious issues. And he also called on the bishops to recommit themselves to Catholic education so that a future generation of articulate and well-educated lay leaders can remain to engage these issues as they arise in the future. John Garvey, the president of the Catholic University of America, has exemplified both of these issues. He has been both an active and engaged lay leader on the public square in the United States, and he has also been a national leader of Catholic education in the United States. And so the John Paul II Guild of Catholic Lawyers is honored to have him here to present this year's Mirror of Justice Award lecture.
Thank you very much, Austin, and thanks to all of you for staying after work to hear me. It's an honor for me to receive the award this year, especially when I see how many of my fellow members of this faculty have received it in the past and what distinguished people they've been. I went to law school at Harvard, and I began my teaching career at the University of Kentucky, two unlikely places to be thinking about Catholic legal education, which is the subject I want to talk about. But even there, I think my faith was not on the sidelines. In my more reflective moments, I began to wonder what about the effect that being Catholic had on the way I thought about the law. A few years ago, for my sins, I was the president of the Association of American Law Schools, and I took the opportunity to invite the American Legal Academy to consider the same question. I think that Catholic University and other religiously affiliated law schools serve an important purpose in American legal education, and that the ALS and other organizations ought to respect and foster their contribution. But I thought that the argument that I was making would be more effective if I framed it in a more inclusive way. There are many distinctive types of law schools in the United States, and we benefit, I think, from protecting their individuality. And so this is the first point I want to make tonight. I call this theme institutional pluralism. And after I describe a few different kinds of institutions, I want to drill down into one of them and see what benefits may accrue from its distinctiveness. I'll focus on religious schools, but what I have to say could be extended to others as well. I maintain that religious schools allow their members to pursue truth and beauty and virtue in special ways, and this is my second point. So let me begin with the first. My wife and I sent our kids to Catholic colleges because we wanted them to integrate their faith and their understanding of art and literature, philosophy, politics, and science. There's a place for this kind of comprehensive wisdom in legal education too. Let me offer just a couple of examples. Catholics believe in the sanctity of human life. This is connected with our theological ideas about creation and the incarnation. And this belief has obvious implications for how we think about criminal punishment. It's difficult, for example, to accept the idea of general deterrence as a justification for punishment. It's also hard to accept the idea of capital punishment. Modesty compels me to admit that Catholics have been slower to come to this conclusion than some other Christian and non-Christian faiths, but that doesn't undercut my point that there's a connection between law and theology. Here's another one. Catholics believe that we should have a special concern for the poor. The Beatitudes in Matthew 5, the parable of the Last Judgment in Matthew 25, teach that the poor are especially blessed and that God will judge us according to how we care for them. The U.S. Catholic Bishop's pastoral letter, Economic Justice for All, of about 2 decades ago, argues that these ideas have a bearing on how we think about unemployment and welfare policy, agricultural programs, and the attitude toward developing nations. I could offer more examples, but you get the idea. A law school where these ideas are in wide circulation is going to have a different intellectual climate than the University of Kentucky. There are 25 Catholic law schools in America. There are, in all, 43 religiously affiliated law schools sponsored by Baptists, Jews, Lutherans, Mormons, the Church of Christ, and other faiths as well. And each of these has its own distinctive character. Religiously affiliated law schools are different, but they're not alone in being different. Let me give a couple other examples. Think, for example, about our sister school across town, Howard University, or North Carolina Central, Texas Southern, or other historically black colleges and universities. In 1935, Charles Hamilton Houston wrote an article about the special mission of Howard Law School. He pointed out how few black lawyers there were in states like Alabama, at the time 4, Mississippi, where there were 6, Louisiana, where there were 8. There were a lot of white lawyers in those states, but he said, experience has proved that the average white lawyer, especially in the South, cannot be relied upon to wage an uncompromising fight for equal rights for Negroes. He has too many conflicting interests, and usually himself profits as an individual by that very exploitation, which as a lawyer he would be called upon to attack and destroy. Houston conceived for Howard a special mission to serve this underserved and underrepresented population. This would mean, among other things, a different academic emphasis. The law of business associations might focus on small businesses rather than multinational corporations. The law of carriers on passengers and shippers rather than management. Life and fire insurance would draw more attention than marine insurance. The HBCUs are like religiously affiliated law schools in several respects. First of all, they have a distinctive mission and a point of view that affects the intellectual culture. And this may have an impact on the subject matter of their curriculum. And they have a special appeal for certain groups of faculty and students as well. Consider now a third class of schools, and take, in this case, our sister school across the river, George Mason. Henry Manny, who is the godfather of that law school, wrote about his vision for it in 1993. The original plan that Manny had called for students to major in different kinds of academic fields, economics, political science, technology, behavioral science. But that proved to be too expensive. So George Mason settled on concentrating on economics. There were a lot of law faculty candidates who were educated in that discipline, and so they could build a faculty. Students at the school would be introduced to the culture through a 6-hour course in their first year in quantitative methods. And nearly every course would have a kind of law and economics flavor. The antonym of George Mason might be another of our neighbors downtown, formerly the Antioch School of Law, which became eventually merged into UDC. Antioch, when I was a child, was started by Edgar and Jean Kahn in 1972. The idea was to train public interest lawyers through a comprehensive clinical method. During their first 2 weeks in the school, students in those days lived with families in poor areas in Washington. And before the first year was out, they and their teachers worked at providing free legal services to these clients. Then there are schools that have a special subject matter focus rather than a point of view. Environmental law like Vermont and Lewis and Clark, or intellectual property like Franklin Pierce. Finally, and maybe I should have started here, there are the state law schools, more than 70 of them. State schools often have a well-defined mission to a particular population. The University of Kentucky, to which I have a special attachment, having spent half my career there, used to negotiate with the legislature every year about how many out-of-state students they could take, and the number was usually small. They're a distinct minority, and of course they pay more tuition. UK has a very well-developed specialty in equine law. You can imagine what that is. Its environmental program at Kentucky and one of its journals pays special attention to coal mining. And the law school and some of its faculty also perform research functions for the General Assembly in Kentucky. So, a close inspection of the ranks of American law schools reveals a surprising degree of variety. There are, as you know, forces arrayed to reduce these differences. The organizations that accredit and review and evaluate law schools, for the most purposes, tend to use the same yardstick for all of them. So, for example, the American Bar Association has traditionally used one set of standards for the approval of law schools. The AALS, my old organization, has 4 core values that it uses in its membership review process. The U.S. News and World Report uses 12 criteria to rank schools from 1 to 200. I think, though, that cultivating differences is a good thing for legal education. At the risk of sounding too sublime, I would say that schools with distinctive missions allow students and their other members to pursue truth and beauty and virtue in a special way. So this is the second part of my talk, and I want to illustrate this point by focusing on religious law schools, but I don't want to limit my point to them. Let me start with truth, something that we're not as comfortable talking about as John Stuart Mill was when he wrote On Liberty. But most of us acknowledge the idea of forward progress in the intellectual life, and I want to argue that institutional pluralism can contribute to this effort. People who have had the privilege of serving in law school administration say that dealing with faculties is like herding cats. Individual faculty members have their own views about teaching and research. They believe academic freedom gives them the right to do these things in their own way. Some of us work in a collaborative style, but this is the exception. The paradigm is the solitary seeker. Imagine, though, a school whose faculty had a set of common interests or concerns. Working together with like-minded people can help us, I think, to conceive and develop and refine new ideas. There's a famous painting in the Vatican, Raphael's fresco, The School of Athens. You may have seen it reproduced. You can see it in the Vatican. The most striking, it depicts a bunch of philosophers, and the striking thing about them is that the philosophers are arrayed in groups. In the middle are Plato and Aristotle talking to one another. In the lower right-hand corner, you will see Euclid and Strabo and Ptolemy. In the top left are what might, as I understand it, be Alcibiades and Xenophon and Parmenides. There's a solitary figure of Heraclitus who's brooding alone, but this is a kind of joke. The face on Heraclitus is the face of Michelangelo, and Raphael is poking fun at his rival's withdrawn personality. The larger message, though, is that we learn best in these groups talking together. What is it about this kind of institutional arrangement that might be good for the progress of legal thought? Let me begin with three things that may help us to arrive sooner or more surely at the truth. Collective action on a common project helps us to share more data, to reason faster, and to mentor one another. This is the set of advantages that moved Vannevar Bush to promote the Manhattan Project in 1941. There was much that we didn't know at the time about the properties of uranium and plutonium, about the arrangement of fissile material to make it explode, or even about the effects of fission. Edward Teller famously worried that a bomb might ignite the atmosphere and cause a fusion reaction of nitrogen nuclei that would blow the world up, and so on. So the project proposed to answer these questions in the shortest possible time by putting a lot of smart people together out in the wilderness in a laboratory in Los Alamos, New Mexico. So why might it work better? Well, one obvious advantage of having a group of people using the same tools or thinking about the same problem is that more people know more. On Sunday mornings or weekends, generally my wife and I do the crossword puzzles together. And we go more than twice as fast as either of us working alone might go. She knows a lot of words that I don't, and this is hardly surprising. We read different books and magazines and have for years. So let us call this advantage more data. There's a second kind of advantage of having several people interested in the same problem that we might call parallel processing. Think about my wife and me doing not the crossword puzzle, but the daily jumbles, those 5 or 6 word, the things that you have to transpose, like it'll say inaco, and you're supposed to figure out that this means oaken, or you might see a word like droven, which you can transpose to mean vendor. But if we're thinking about these together at the same time in parallel, we can go faster not because we have more data, but because we can run through more permutations at the same time. Here's a third one, a third advantage to collective intellectual effort, and it's mentoring. when I was a young law professor at the University of Kentucky, I used to have lunch all the time with Pat Smith, who was the chair of the philosophy department. She was a lawyer and a philosopher from Arizona. She was a student of Joel Feinberg's. And when I wanted a short course on action theory, or I wanted a list of John Rawls's critics, I would have lunch with Pat, and she would walk me through the literature. I would estimate that over the course of a dozen years collaboration, she probably saved me a year of work in what I would have had to do. Here's another example from Walter Isaacson's Biography of Einstein, which I read a couple of summers ago. People say that Einstein was a better physicist than mathematician. The point's exaggerated. I mean, he was a better mathematician than all of us, but there is some truth in it. And when Einstein moved from Prague to Zurich in 1912, he asked his friend Marcel Grossmann to help him with non-Euclidean geometry. And it was, Isaacson says, the introduction to Riemann's metric tensors that allowed Einstein to find a way of capturing the general theory of relativity, the idea that gravity can be defined as a curvature of space-time. In A Theory of Justice, John Rawls refers to these advantages in his discussion about the status of majority rule. And here's what Rawls has to say. The benefits from discussion lie in the fact that people are limited in knowledge and the ability to reason. No one of them knows everything the others know, or can make all the same inferences that they can draw in concert. Discussion is a way of combining information and enlarging the range of arguments. At least in the course of time, the effects of common deliberation seem bound to improve matters. There's, if you're familiar with Condorcet's jury theorem, you'll see some support for this. Condorcet's theorem is the idea that is much studied these days by democratic theorists. He proposed that a large group choosing between two outcomes will decide them better, or better than an individual anyway, at least if each member of the group has a better than 50% chance of being right. Here's a famous example from a book by James Surowiecki. In 1905, the West of England Fat Stock and Poultry Exhibition held a weight judging competition for a fat ox. The idea was that the competitors, the people playing the game, would pay 6 pence to guess how much the ox would weigh after it was slaughtered and dressed. Well, and the winner got prizes, and there were 800 people who paid 6 pence for this privilege. Francis Galton, who was a scientist from Plymouth and who attended the fair, collected all the tickets with the numbers on them afterwards and added the guesses and took the average. The crowd guessed that the ox would weigh 1,197 pounds. The actual weight was 1,198 pounds. The same phenomenon accounts, I think, for the remarkable success of the members of the Society of American Baseball Research, the SABR, in predicting the winners of baseball playoffs. You can do the math on this. In a group of 3 people, if each member has a 67% chance of being right, a majority vote has a likelihood of 74% chance of being right. And the number goes up as the size of the crowd gets bigger. So, this is a good argument for collective intellectual inquiries. But what does it say about my more refined point that we want not just large groups, but specially constituted groups? Part of the answer, I think, is obvious from my example. It's a good thing for members of a group to have different ideas, but they need to be working on the same problem, the weight of an ox, the baseball playoffs. We control for this by looking for faculty who are interested in, for example, the role of faith in the specification of legal rules. But there are qualifications to Condorcet's theorem that also bear on the work of law schools that aspire to be different. And let me mention 1 or 2. Some of these result from the very model that we're trying to construct. Consider the difference between the Columbus School of Law and the crowd estimating the weight of the ox at the West of England Fat Stock and Poultry Exhibition. The crowd is what we might call a statistical group. 800 individuals who act independently of one another. They don't consult before making their estimates, and they're unaware of what other group members are doing. The Columbus School of Law, by contrast, is what we might call a deliberative group. We talk to each other all the time, at lunch, at faculty meetings, at colloquia like this, in office visits, in team-taught classes, in co-authored pieces. Condorcet's theorem assumes that group members' votes will be independent of each other. Deliberative groups exist for the purpose of facilitating interpersonal influence. We share data and hypotheses, we mentor one another. So what effect does this have on our hypothesis? Cass Sunstein argues that it can lead to deliberative failure for several reasons. One is the influence of what he calls informational signals. If most group members share a particular belief, other members, or those with a minority view, might not speak out because they respect the information signals given by the statements of others. Sunstein suggests that something like this happened with the CIA's inquiry into the existence of weapons of mass destruction in Iraq. There was information available within the agency that contradicted the prevailing assumptions about weapons of mass destruction, but those who had it hesitated to speak out. Here's another example, which I'll give you after I blow my nose. My wife and I recently had an argument about sensory processing disorders. This malady is invoked by doctors with increasing frequency to explain behavior that 20 years ago I would have said could be cured with a good spanking. I likened it to what my mother called diseases of the rich, medical explanations, dyslexia, ADHD, for why Johnny can't read. There is some support for my position. John Burnham in the New England Journal of Medicine writes about the phenomenon of bandwagon diseases. In these cases, he says, doctors behave like lemmings, pushing certain diseases and treatments primarily because everyone else is doing the same. So that's the problem of information signals. A second reason for deliberative failure is the problem of social influences. Some people shrink back from contributing to group deliberations, not out of modesty or deference, but for fear of social punishment. The phenomenon of political correctness is a good example. It comes in all flavors. You have no doubt heard the common assumption outsiders make about religious colleges and universities, that we suppress dissent through higher authority, intramural rules, and social pressures. There is, I think, little truth in this assumption, but it's a powerful argument for protecting academic freedom, especially religiously affiliated law schools, because we will fulfill our own objectives better if we encourage the free exchange of information and flow of argument. In its old approach to the canonization of saints, the Catholic Church actually went a step further. It built into the process a mechanism designed to counteract the influence of social pressure and information cascades. A canon lawyer who was called the devil's advocate was appointed for the express purpose of opposing the case. He would look for flaws in the candidate's character, reasons to believe that the miracles attributed to the candidate were fake, and so on. Okay, so I've been talking about the collective pursuit of truth. Let me turn, it's an idea that lawyers are especially devoted to. The point of trials is to find truth so we can assign responsibility, but truth isn't the only ideal that universities set before themselves. Beauty is another, and I'd like to turn to it now. It too is often a cultural achievement. It's a product of collective endeavor. Another feature of institutional pluralism, the arrangement that I'm arguing for, is the contribution it makes to this aesthetic or style or culture. Let me give 3 examples. I mentioned earlier the School of Athens, a fresco that Raphael did in 1510 and 11 for Pope Julius II's library in the Vatican. At precisely the same time, Julius II, a famous patron of the arts, had commissioned Michelangelo to paint the Sistine Chapel. Michelangelo didn't want the commission. He was a sculptor and thought of himself as that and wanted to do Julius's tomb. He didn't know much about painting frescoes. He had done the Pietà and he'd done the David, and that's how he'd made his reputation. So to do the Sistine Chapel ceiling on frescoes, he had to learn how to transfer a design from a cartoon to a wet plaster. He had to learn what kind of pigments work best in the medium and how to manage perspective on a curved surface that was 60 feet above the ground and so on. And he learned this from Raphael. And he, in turn, taught Raphael some things. I mentioned the figure of Heraclitus in the school of Athens. If you look at it, you'll notice that unlike some of Raphael's figures, it has that kind of rugged, powerful, blocky look that Michelangelo's prophets have. So here's a second example, again, from painting. The Venetian school of painting in the 15th and 16th century, about the same time. Bellini and Giorgione, Titian, Tintoretto, Veronese, Lotto, those guys. There were things that Venice was a small town, I mean, compared to LA these days or Mexico City, but there was a lot that they shared and collectively developed. There, you will see in this school an interest in light and color that anticipates the Impressionists of 400 years later. There's a distinctive kind of brushwork that gives their paintings a really smooth appearance. And of course, they had to learn how to work in oils, a development that was born of necessity because Venice has got canals, and so it's got a lot of damp air, and so it needs a medium that will survive that sort of thing. Here's another one. I know little about violins, but I find it interesting that 500 years after the birth of Andrea Amati, people still think that the best violins ever made in the history of the world were all made in the little town of Cremona, Italy, all by apprentices of Niccolò Amati, Antonio Stradivari, and Giuseppe Guarnari. I don't know whether it's the design or the wood or the varnish or the craftsmanship, but they had some tricks of the trade which died with them, and we find ourselves unable to replicate it. It was the culture that did it in that little town. This development of an aesthetic is a collective effort to which individual participants make small contributions. We've seen it in legal education, in the development of schools like legal realism, legal process, critical legal studies, law and economics, public choice theory, feminist jurisprudence, critical race theory, the law and society movement, and so on. Finally, there's what I might call the coffee house effect, the communication of similar ideas across different fields. I'm not sure I can describe how this works, but one of my favorite history books, Karl Schorsky's Fin de siècle of Vienna, explains about how from in the turn of the 19th to the 20th century in the coffee houses of Vienna, revolutionary changes communicated themselves across different fields. Take, for example, the expressionist painter Oskar Kokoschka and the atonal musician Arnold Schoenberg. They both share an idea about everything being in flux. Or think about Freud, who was another one of these in psychology, and Gustav Klimt in art, who began to explore the world of instinct and self and the interior life in their work. So we have all of these things conspiring together to create cultures that improve our sense of beauty. Okay, so to this point, I've talked about the intellectual benefits of institutional pluralism. I've been talking about the pursuit of truth and of beauty. If you peruse the websites of religiously affiliated law schools, you will see something else as well. Take Brigham Young University's J. Reuben Clark School of Law. Their admissions process says that they are looking for students who are willing to live by, quote, those moral values encompassed in the gospel of Jesus Christ, and to, among other things, be honest, live a chaste life, respect others, and observe the virtue of temperance. Pepperdine Law School looks for something similar. Here's what it says. The school's Christian emphasis leads to a special concern for imbuing students with the highest principles of professional, ethical, and moral responsibility. An effort is made to call together a faculty, staff, and student body who wish to share this experience of quality legal education in a value-centered context. If I can state these objectives more generally, some schools seek to offer, as part of their educational experience, help in the formation of particular qualities of character. The schools that do this are preeminently religiously affiliated law schools, but there are other institutions that exhibit a similar aim. I mentioned the University of the District of Columbia, formerly Antioch. And it asks students to, quote, build upon each other's consciousness and spirit. It seeks to instill in them, quote, a dedication to public service and causes that affect the quality of life in this country and throughout the world. I want to offer a few concluding observations on institutional pluralism and the cultivation of virtue, and then I'm going to close with two doubts that I have about my thesis. I think the cultivation of virtue, as I have said often here, is an appropriate undertaking for universities, and not just because universities cater to young people whose characters are unformed. I think that there is a connection between virtue and knowledge. Aristotle says that if you want to listen intelligently to lectures on ethics, you must have been brought up in good habits. Reason may be that it's hard to reason about ends. The particular goals that we set for ourselves are illuminated by our character or our moral orientation. We might aim at promoting family integrity or temperance or chastity among young adults, as BYU does. In efforts like these, Aristotle says, virtue makes us aim at the right mark, and practical wisdom makes us take the right means. In classes on family law, we'll think differently about the grounds for divorce and alimony obligations if our aim is to keep families together than we will if our aim is to promote individual autonomy. This isn't a complete argument, though. I've said that virtue has some bearing on how we learn, but what exactly is the institution's role in this? And why is it good to have different kinds of institutions? Let me offer three thoughts on the subject of institutions and virtue in education. First of all, the understanding and refinement of virtue is essentially a collective, not a solitary undertaking. Think, to choose an unlikely source, Burke's observation in his reflections on the revolution in France. Burke says, the science of government, being a matter which requires more experience than any one person can gain in his whole life, however sagacious and observing he may be, it is with infinite caution that any man ought to venture upon pulling down an edifice or on building it up again without having models and patterns of approved utility before his eyes. Here's a cognate argument from another unlikely source, Hayek. Hayek says that virtue is a product of markets, not traditions, but otherwise he sounds a lot like Burke. He says, in his, this is from the Origins and Effects of Morals, human morality is itself the product of many minds, making their decisions over long periods of time in a way that produces a set of principles that no individual mind and no theory is likely to capture. We Catholics have, I think, an even more robust notion of the collective pursuit of virtue. To the Church, the Catechism says, belongs the right to announce moral principles, including those pertaining to the social order. This is not on all fours with my other examples. The Church believes its understanding is directed by the Holy Spirit, a surer guide, I think, than the invisible hand of the market, but the same idea. The Church also has a fairly settled view of the moral law. It's not susceptible to further improvement. And the faithful don't contribute in equal ways to our collective grasp of the moral law. Unlike the market and the British Commonwealth, the Church is not a democracy. These are important differences, but they don't negate the essential argument on this point, that we come to understand virtue in groups and not in private contemplation. The point I've been making is that the understanding of virtue is a collective achievement, like the development of a language or a culture. Here's a second point I want to make, and it's similar, but it's about the cell, not the organism. The individual, I think, learns virtue best as a member of a group. This is true for several reasons. One is that we acquire virtue by imitation and practice, not just comprehension. It's more like baseball or yoga or telephone manners than it is like geometry. As the Catholic Catechism says, the Christian learns the example of holiness from the church. He discerns it in the authentic witness of those who live it. So if I had a lot of money to spend on learning virtue, I might want to hire a swing coach, a kind of moral Bruce Harmon, or a yoga master to teach me holiness. But groups have this additional advantage over swamis. Besides offering swing tips, they provide a counterweight to the culture. In raising our children, my wife and I have found that it's hard to fight the culture. We deliver one kind of message about materialism and sex and self-sacrifice and alcohol. Our children see another set of directions in the media and in school. Our lesson gains credibility with the kids if they see it in a community of people that they know and admire who live it. So that's my second point. My third point is about virtue and institutional pluralism. Law schools differ from one another in the virtues that they stress. Let me illustrate this point in a different context. In the Roman Catholic Church, there are hundreds of orders of religious men and women who form different kinds of communities characterized by different charisms. The Missionaries of Charity, begun by Mother Teresa, give wholehearted and free service to the poorest of the poor. The Trappists, Thomas Merton is a famous example, live lives of silence, doing manual labor, fasting and abstaining from meat. They take a vow of stability, and they aim to devote themselves to prayer and contemplation. The Jesuits run colleges and universities like BC and Georgetown and Fordham. They educate, in fact, about 10% of the lawyers in the United States. They espouse a particular form of spirituality that includes twice daily examinations of conscience and an effort to find God in all things. This kind of focus leads to a more active ministry than the Trappists or other monastic orders, who seek to find God by withdrawing from the world. There is not a hierarchy among these orders. I don't think that one is more holy or worthy of imitation than another. Praying and serving the poor and training lawyers are all, we would say, roads to heaven. For one called to the religious life, the choice among them depends on his or her talents and aesthetic preferences. I have a friend who joined the Dominicans because he liked the habit. And so it is with law schools. In the world of legal education, we would be a poorer place if we didn't offer training in a variety of virtues as well as intellectual pursuits. Not many schools stress temperance as BYU does in their education plan, but in the Christian tradition, self-control is one of the big ones. The most common cause of ethical trouble among lawyers is substance abuse. That's one reason to teach temperance. Another one is that self-control matters in a lot of ways in a lawyer's life. Aquinas observes, for example, that clemency is an offshoot of temperance. It's a restraint of the desire to punish. Okay, so I'm done with my 2 points. Let me just finish with a couple of questions which you may have had in mind already. I've been trying to sketch a picture of institutional pluralism in legal education and to suggest some ways that schools with distinct cultures might serve their students better. I now want to mention some doubts that I entertain about my own idea. The first is big. Institutional pluralism may be impossible. David Reisman once gave some lectures at the University of Nebraska. It's a really interesting little book published under the name of Constraint and Variety in American Education, in which he talks about a failed effort he made early in his career to build a distinctive law school at the University of Buffalo. his idea was, he said, to develop a curriculum that was not merely a minor league version of the Eastern Seaboard schools, but rather one which was designed with reference to the particular problems of Western New York. The effort failed, he says, because of three homogenizing influences. First, at least half the faculty and all but one of the younger people had gone to law school at Harvard. They wanted to teach the courses that were held in high esteem at Harvard. And their contacts in the legal world were their classmates, most of whom had gone to work for Sullivan and Cromwell in New York City or for the government in Washington. So they naturally pointed their students in these directions. Second, good students tended to have their eyes on the Supreme Court and the SEC, not the Buffalo City Planning Commission. And third, the faculty and the administration were interested in building an institution that would succeed according to the established norms of ranking, which did not include among its criteria the sort of distinctiveness that Reisman was trying to build up. Some of these objections, I think, have a little less force today than they did 70 years ago when he taught at Buffalo. There are more good law schools today competing with Harvard. I don't mean just Yale and Chicago and Stanford. There's a much more vibrant intellectual life in the American Legal Academy today than there was 70 years ago. Young faculty must write before they can get hired. They have more and different role models. Couples more often seek institutions that may not be found in Cambridge or New Haven. It may be that we're better able, at a half a century's remove, to resist the temptation to all be like Harvard. Here's a second kind of objection. Even if we could make institutional pluralism work, it might be a bad idea. Maybe what we want is diversity within institutions, not pluralism among institutions. Maybe the best way to discover truth, as the lawyers say, is out of a multitude of tongues rather than through a collective effort. Mill says it's good to have dissent, not everybody walking in the same direction, because, first of all, an unpopular opinion might be true, and even if it's not, second, we'll understand the truth better if we have to defend it. This objection, I think, is a red herring. Even if institutional pluralism meant that private schools could limit unorthodox expression, and it does not, we would still have disagreement between institutions. It's not clear that Mill's argument entails protection for dissent at every level. More importantly, though, the idea of a distinctive institutional culture is not inconsistent with individual freedom of inquiry. As I said earlier, we will achieve our own objectives better if we encourage the free exchange of information and flow of argument. So, that's all I have to say. Institutional pluralism is, I think, a familiar phenomenon. Most of us work in places like this, but it's one we haven't fully embraced in the legal academy. I think it would be a very healthy thing, both for our students and for the intellectual life, if we paid attention to it. Schools don't need to compete on the same track to succeed, and in that more pluralistic world, I think that Catholic law schools have something very special to contribute. So, thank you for giving me the chance to say all of this. I don't ordinarily get to talk about such interesting things. So, I'm...
Legal education and for serving as a great example to the rest of us. On behalf of the Pope John Paul II Guild of Catholic Lawyers, I present to you with the Mary Mirror of Justice Award.
Thank you very much.
Thank you.